once again, welcome to this panel, which is entitled Beyond Snowden, a Surveillance Reform Update. I am Deborah Hurley of Brown University. Let me introduce the speakers briefly. Their extended biographical information is available through the Cpdp materials. Can you hear me? Mixed results. Okay. All right. I'm going into coxswain mode then. Okay, fine. So let me introduce the speakers here. So I'll start down at the far end on my right. On your left is Tim Edgar of Brown University. He is also the author of the publication Beyond Snowden, Privacy, Mass Surveillance, and the Struggle to Reform the NSA. Next to him is Jason Biros, who is with the U.S. Department of State, and he is with the U.S. mission to the EU. Immediately next to me is Katitza Rodriguez, who is the International Rights Director of the Electronic Frontier Foundation, EFF. Immediately to my left is Anna Roth, who is the advisor to the German Parliament for the NSA Inquiry Committee. And at my far left is Gus Hosein, who is the Executive Director of Privacy International. So just to begin briefly, the worldwide release of information about US surveillance, which was obtained by Edward Snowden, produced shockwaves that are still with us today. The information revealed levels of surveillance and types of surveillance that, although there were people in the advocacy community aware of it and others aware of it throughout the government and the intelligence community, revealed types of surveillance and extent of surveillance that was largely unknown to the public. This produced outrage and many kinds of inquiries, demonstrations, governmental inquiries, legislative reform, and so forth, some of it formal and some of it informal. And that's gone on for the last 4 or 5 years. So the purpose of this panel today is to examine now, 4 to 5 years on, the state of surveillance reform. Where have reforms occurred? What are those reforms? And equally significantly, where has reform not occurred and what's going to happen there? So I remember very well the day that this information was first released. It was June 5th, 2013 that it was released to the wide public. I don't live in DC, but I happened to be in DC that day. And I pulled the Washington Post into my room, into my hotel room, and the headline was about NSA surveillance of Verizon, the deal with Verizon to receive information about US telephone calls. I was actually in Washington that day to go with Steve Aftergood, who is an employee of the Federation of American Scientists, and he oversees the government secrecy project there. And Steve Aftergood and I in my role as chair of the board of directors of EPIC, we're going to meet with Charles McCullough, who was the relatively newly appointed Inspector General of the intelligence community. And we were meeting with him at his office at the CIA. So I read that headline, that very curious headline, and then headed over to the CIA with Steve to meet with Charles McCullough about the intelligence community's Inspector General. And we talked about the establishment of that office, the jurisdiction of that office, the structure of the intelligence community oversight, and what would happen. So it was a very memorable and surreal pair of bookends for that particular day for me. So I'm going to turn it over now to our first speaker, who is Tim Edgar. Tim.
Thank you very much, Deborah. I am Tim Edgar, and I also have strong memories of that day. I was wrapping up my decision to leave a 6-year stint in the U.S. government. A really unusual, role for me was to be protecting privacy in the agencies of the U.S. government that basically are designed to gather and collect massive amounts of intelligence information. And I had been, engaged in this activity since the middle of the Bush administration. And it was an unusual decision on my part because my role was, I came into government as a civil libertarian. I was a civil liberties lawyer and activist for the ACLU. on 9/11. I had worked for 6 years working in Congress, making arguments about why we needed to protect civil liberties, why we needed warrants for surveillance, criticizing new powers like the Patriot Act. And when the government decided to reorganize the intelligence community at the recommendation of the 9/11 Commission in the Bush years, the idea was to appoint a single person in charge of U.S. intelligence, a director of national intelligence, to coordinate across the various divides of the agencies. And one of those important divides was the divide between foreign and domestic intelligence. And so this poses obvious privacy issues, civil liberties issues, which I want to get back to at the end of what I think of as the most significant change that we've seen because of the Snowden revelations. So I thought long and hard about, did I really want to go into the belly of the mass surveillance beast, which I didn't know was the mass surveillance beast quite yet, but the surveillance beast anyway. And I decided that I would try to make a difference by going on the inside. Giving up my ability to criticize publicly what was going on, but getting a unique insight into what the government was doing. And learned very quickly, very early on, about how the government was using some of its powers, how the U.S. government had used the Patriot Act and other laws to create the beginnings of a kind of mass surveillance state. Didn't necessarily think of it that way, but that's really what it was, because we were talking about large-scale collection of bulk databases, and particularly the big innovation using the powers in the Patriot Act was to collect data that was domestic data, but which might involve targets that were overseas, might involve transnational threats like terrorism. And we worked very hard over several years to grapple with those programs, to put in place privacy safeguards, to take programs that had been begun under purely presidential authority after 9/11 and put them under the authority of the Foreign Intelligence Surveillance Court, the FISA court, and under statutory authority. But it required a lot of stretching of the law, frankly, a lot of creative interpretations of the law in order to try to rationalize and institutionalize some of those practices. And I'm proud of some of the accomplishments that we made in those 5 or 6 years. I ended up going on to serve in the White House during the Obama years as a privacy official there. But then in June of 2013, not because I was resigning in protest or running off with a cache of secret documents to Hong Kong, but because I was getting married and had gotten a good job offer from my wife's university at Brown University, I decided to leave the government. And it just so happened that basically the day after I signed those final paperwork and made myself a free man from the intelligence community, Edward Snowden comes along and talks about all the stuff we had worked on over the past 6 years. And I knew that I was now going to be talking about things that I had never expected to talk about, things like bulk collection that had been classified at the highest levels of the U.S. government. Over the next 5 years, 4.5 years roughly, I became kind of an observer and participant in the debate over surveillance reform, and here are some observations that I have about it. I think the main observation I have is that the reform conversation in the first few years especially was much broader. The reaction was much bigger. It lasted for a much longer period of time than anyone, certainly inside the government, but I even think outside the government, could possibly have imagined. And I think that's because the world had changed in important ways in the beginning of the 21st century, in ways that made this issue of mass surveillance resonate with the global public and with Americans. Our laws and privacy rules, our Constitution, our statutes like the Foreign Intelligence Surveillance Act or executive orders like Executive Order 12333, were all designed to basically try to draw that line between Americans and foreigners and say, here are the privacy interests we're trying to protect against possible abuses by intelligence agencies, and when it comes to external activities, they're going to be regulated, if at all, by some pretty loose policy considerations. And that had always been the paradigm up until, I would say, 2013. And when there had been scandals involving surveillance or spying, the scandals had revolved around, are you U.S., you know, the CIA, are you NSA, are you misusing the powers that you have to fight against external threats to look inside domestically? And the idea that maybe you are misusing the powers that you have to spy overseas because maybe the privacy interests of people overseas matter was simply not on the radar screen. And I think Edward Snowden's revelations put those issues on the radar screen. And I would identify two reasons for that. One is the critical relationships that the United States intelligence community has with governments all over the world, especially in Europe. And so when there's a global public reaction to those kinds of detailed revelations of spying, it puts pressure on those governments to react, and that puts pressure on the US government. The second reason is the growth, and perhaps the more important reason, is the growth of the US technology industry with customers all over the world. And this industry was particularly close to the president I worked for, President Obama. And so when the intelligence community came out with its standard defense of these activities, you know, we have protections for US persons, we have protections for Americans, and we're following those. People like Larry Page and other tech executives said, this is not helping us. This is hurting us in the global marketplace. So as a result, we ended up with some important reforms. I don't have time to go into detail on all of them, but we can get into detail on some of them. But I'd just like to tick off a couple. One is Presidential Policy Directive 28. We can debate just how significant the protections are in that directive. But the fact that it exists at all, the fact that there is a directive issued by the intelligence community in the United States that says the interests of foreigners matter was really a sea change in terms of just theoretically, conceptually, it was a sea change for the intelligence community. When I worked inside the intelligence community, when I told people I worked on privacy issues, immediately they said, oh, you're the one who cares about Americans. And I didn't really question that. That seemed about right to me. With 2013, Snowden revelations, PPD 28, that's not true anymore. Other changes involving bulk collection, the US Congress made in 2015 to reform that practice in the USA Freedom Act. And then I suspect in this conversation we'll talk a little bit about 702, FISA 702, that allows collection of foreign data inside the United States, recently renewed by the US Congress with some modest reforms. But my bottom line is that I think we're in a new phase, a new conversation in which we have a lot more transparency about these surveillance practices, in which we are debating issues of accountability that didn't go debated before. And I want to talk a little bit not just about the US experience, but thinking about other countries, the UK, Germany, others. And in particular, the UK's experience I think is an interesting comparison and contrast to the US experience. One of the similarities is that because of the increased transparency around UK surveillance practices, in their more recent surveillance statute, I think they were required both to kind of explain what those practices are and rationalize them, to authorize them in law in ways that they hadn't been authorized before, and also put in place some additional protections. Where I think the contrast is, and it's partly because of the different culture involved, is the fact that the UK's just authorized widespread new surveillance practices in ways that we didn't see in the US. I think there's been different experiences based on different cultures, but certainly we've been having a pretty broad conversation in the last 5 years, and it didn't stop after a few months as we thought might be the case in 2013.
Thank you very much, Tim. Gus Hosein is the moderator of our panel, so I'm going to ask Gus if he'd like to ask Tim a question.
Tim, if there was a moment in time where there was positive reform, say in the 2 years, as you argued, and then we saw 702 being a bit of a debacle as a process now, with the state of politics in the US right now, what would it take for meaningful reform to be back on the agenda? Another Snowden? Another Trump?
Well, I have to say the Trump phenomenon has surprised me because I think it's resulted in less concern around surveillance than I would have expected. And I think in some ways it's had the opposite effect of what I would have predicted a year ago. You know, when I wrote Beyond Snowden, I thought there were two dangers posed by Trump. The first was kind of the obvious danger, an authoritarian or authoritarian-sounding leader, you know, a lot of race-basing, Muslim baiting. In the event of a terrorist attack, we would see new and more draconian powers of surveillance. And in fact, Trump had promised new and more draconian powers of surveillance in the campaign. The other danger, I thought, was in the fight between Trump and the intelligence community, again, kind of lashing out to try to find leakers has in the past resulted in surveillance abuses. In a strange way, I still think those are the two dangers. But I also think that the fight between Trump and the intelligence community has in an odd way put many moderate Democrats on the side of the intelligence community and actually strengthened or weakened the case for surveillance reform in Congress in ways I would not have expected. So if you look at the votes on 702 on the main reform proposal, which was to add warrants for Americans, those votes went down to resounding defeat in both the House and the Senate. And I think a lot of the reason for that is a concern among a lot of Democrats that, you know, this is something the intelligence community needs. And when Trump went out and criticized that power on the day of the vote, it was sort of odd, you know, the President of the United States basically undermining his own position in front of Congress in a tweet. I actually think that might have swayed some votes in favor of, you know, voting for that power. In other words, Trump says, I was watching Fox News and this is the same law they used to, you know, Robert Mueller is using to abuse me. Okay, well, I'm going to vote for that then. So that I think is the short term. In the longer term, I actually think that the biggest potential trigger for more surveillance reform in the United States is another loss in the European Court of Justice. More international legal challenges that basically hold the US government accountable and say, okay, we've read what you do to reform surveillance. You know, nice job, guys, but it doesn't go far enough. And if that's done in ways that really require a response, which means, you know, not sort of a statement from the Human Rights Commission in the UN, but a statement from the European Union, which could threaten international data transfers, you may see a significant reaction. But I do get the sense that at least you know, we're not at the, to paraphrase Churchill, I don't think we're at the end or the beginning of the end, but we are at the end of the beginning when it comes to surveillance reform with the renewal of 702.
Great, thank you, Tim. And the message there is Max Schrems, keep it up and get a posse to do it with you. Okay, our next speaker now is Anna Roth.
Thank you. Welcome everybody. My task now is to both introduce and explain a little bit about an instrument that was set up in the German parliament after Snowden, the German inquiry on mass surveillance, and then maybe also try to give a bit of a glimpse on what happened after and was there any changes. So, and also explain about my role a little. An inquiry in the German parliament is an investigation basically against the government, and maybe to explain the term government here, I think the American understanding of government is both the administration and the parliament, while in German politics, that's the government is the head of government, that's the Chancellor Merkel and the ministries, while the parliament are not to be considered government. So when I talk about government, I don't mean parliament, just to be clear about that. So the parliament basically decided in an election right after Snowden in September 2013 to have such an investigation against the government and to find out how the Snowden revelations actually played out in Germany. So is this type of mass surveillance, as we learned about, is that happening in Germany and how? And are the German secret services cooperating? And what did the government know about it? That was mainly our task. There were some other aspects also, for example, how is Germany cooperating with the drone war, which also through the US bases in Germany was a vital point, but I'm not going to go into that. My role was, I was the senior advisor of one of the four parties in parliament, one of the two small opposition parties that were basically up against both the majority in parliament, backing Merkel, and against the secret services and the government. The inquiry was established finally in 2014 and was finished last summer with a huge report of close to 2,000 pages. So that was one of the results. There is a lot in that. Unfortunately, we don't have it in English. If you are interested, come talk to me later. I think there is a lot more than I'm going to be able to touch now in the report. But because we're talking about the outcomes or the aftermath of Snowden, I'll try to talk a bit about those results that actually touch the area of parliamentary oversight and the troubles that we found in the inquiry, and how that sort of turned into law afterwards. Also, maybe to explain that the inquiry is it's a constitutional right. Actually, it's written in the German constitution. It's a very strong instrument. It's sort of like a prosecution, and you can imagine a bit like a court case. We hear witnesses. We have the right to demand files and have a look at those. And what I find interesting about this is actually the lack of such investigations in other countries. Germany, I think, is the only country that had such a investigation over several years. There were a short inquiry in Brazil, and then there was a short investigation in the European Parliament. But other than that, I'm not aware that any other country actually tried to find out in such a public way also, and granting so many rights to the investigation as the one we had, which I think makes it also quite interesting to hear about. And so the results, other than the long report, I think the main result basically is yes, Germany is cooperating with the system of mass surveillance as Snowden explained it. There is no surprise in that. Basically the way how that happened is also how Snowden explained it very well, which is the NSA basically gives hardware and software for interception, and the partnering countries return data in exchange. And that's what's happening in Germany as well. A lot of the shared intercepted data was shared with the Five Eyes, specifically the NSA, one issue that we talked about a lot and put a lot of energy into understanding how that worked is, of course, that Germany, just like, for example, the US, has special rights granted to German citizens, as they are not allowed to be monitored by the German Foreign Secret Service, which is the Bundesnachrichtendienst, or BND, monitoring outside of Germany, but is not allowed to surveil German citizens. And so how actually did this filtering happen, while at the same time the other partner, the US, was also making sure that no US citizen surveillance was handed over to them. And that's what we looked at for quite a while. We found a whole range of illegal activities actually being done by the German secret services. One of the results that was never there before is that the German government openly and publicly criticized its own intelligence service after a lot of these scandals had become public. That is rather unusual, I think. The head of the BND lost his job over the whole procedure. But other than that, I think the system basically is in place also because the German government considers itself to be a staunch ally to the United States and is not, as such, questioning the cooperation. One of the, maybe from a legal point of view, most interesting results is that we basically understood through the investigation that the law governing the privacy of communication, which in German is called the G10 law, was basically broken because it was designed at a time that a law was made in 2001 that was designed for circuit-switched communication, which allows to actually separate communication in a different way than is possible once digital communication took over about 10 years ago. But the law wasn't adapted actually to that. I think it's a bit too detailed to explain exactly. If you're interested in that type of thing, also again, come and ask me later how we found about these details. But the interesting thing, I think, is that the BND was intercepting communication in cooperation with the NSA based on that law, but actually couldn't follow the law anymore because that required certain things that were technically not possible once communication switched to packet switching. What you would have expected is that then the intelligence goes to the government and says, you know, the laws that we have technically don't make sense anymore, and if we are to abide them, then the laws need to be changed. This never happened. So the cooperation went on. and also the oversight panels that were tasked with overseeing these procedures actually had no idea this was happening, because one, they did not have the technical capacity to actually understand what was happening, but also because they weren't told. I think that those were one of the really fundamental eruptions also in German discussion about what was actually going on, understanding and really seeing how much intelligence was actually lying to the government, lying to the parliament, lying to the public, and for years, and not really caring much about it. Two other maybe small aspects that I just want to mention. You're probably aware of the system of selectors being used to filter intercepted mass communication, which is basically search terms to go for the targets that intelligence is actually interested in. There is millions and billions of such selectors. Also in Germany we found out that them exist. And I think the oversight committees, or I know the oversight committees knew that such a system existed, except they never knew what actually the targets were. And one of the reasons for why that is the construction of how these cooperations take place. A cooperation between the BND and the NSA is based on a contract. The contract is made between the intelligence services, not by the parliaments, not by the government. So there was a contract the parliament never saw. And in this contract, there is a specific aspect called the third-party rule. And the third-party rule says that each partner that wants to tell anyone else, a third party, about any detail of the cooperation needs to get approval of the other partner in the contract, meaning the parliament had no chance to actually know about the technical details, but also about the selectors being used by the BND to intercept German data intercepted in Germany, and then handed over to the NSA. And surprise, it was found through the investigation that a lot of these targets were not what you would think are the task of intelligence as by law, for example, terrorism, organized crime, proliferation, but instead was other governments, EU institutions, also journalists or non-governmental organizations. So that's just some of the results, and because I'm also already ending my time and want to get into what happened after Germany, the German parliament made 2 new laws, actually while the inquiry was still going on, before it had ended, which we protested against, but anyway. And one governing the Bundesnachrichtendienst, the Foreign Intelligence Service, and to make it short, it's not a good law. It actually basically legalizes what was found to be illegal before. There were huge protests by Reporters Without Borders, by Amnesty International. A number of special rapporteurs to the United Nations protested against it. In an interesting report published by Joe Kanatachi last year, he said, "There is little or no evidence to persuade me of either the efficacy of the proportionality of some of the extremely intrusive measures that have been introduced by new surveillance laws in France, Germany, the UK, and the USA." So it's not just me saying these laws are not a good idea, but actually there's a number of protests against this. One of the reasons why that is, and that was also an argument in the inquiry, is this distinction between German and non-German citizens. Same argument, I'm sure, are happening in many other countries, and I think there was a panel this morning touching exactly that reason. We had several former constitutional judges in the inquiry, but also later when the law was made, saying it is not constitutional in Germany to define a fundamental law to be a national right just for German citizens. These are universal fundamental rights, and based on that, several other things are not constitutional based on that. So I'm going to stop here. I could talk a lot more about why the law is not a good idea. It actually extends mass surveillance. It allows surveillance on journalists and other people abroad, et cetera, et cetera. And then there is also an oversight law, and I'm just going to mention that here and stop now.
Thank you very much, Anna. Gus, your question?
There's a theme to my questions, and that is, if you've described intelligence sharing, which is practically impossible to get people to understand and care about, but like most fields would kill for an Edward Snowden. The environmental movement would kill to have an Edward Snowden type of person come forward and say this is what's going on, reform would happen. And we've heard how in the US reform is slowing down, and going in reverse in some cases. And in Germany, you were trying to reform something that was still really hard to explain. So can you try to imagine, explain to us what the perfect whistleblower would be to enliven the German debate again, to get real reform going ahead again?
What Germany absolutely needs and didn't have yet is a whistleblower from inside the German intelligence services. Still, we have this debate of people saying, you know, but for one, we don't know exactly what the Americans do. Basically, we are sort of totally bound by what they do, because they basically sort of force us to comply, because without them we would be totally lost, and we would be doomed, and who knows what would be happening. We had a similar experience with GCHQ, and therefore we just need the cooperation. And there's many details that we actually don't know yet about how exactly that's happening. We know a lot, and there's some of that I can talk about, and but there's also still a lot of knowledge missing. And we are confronted with an intelligence service that basically says, well, you have no idea what's going on, but also it's better that you don't know, and just trust us. And we have plenty of examples not to trust them, so we need whistleblowers from intelligence. Also, another reason is that Snowden is already now 5 years ago, right? And what he talked about is 5 years old, and in technology that is like a century. So we need to know more. Again, also for people, again, I think to revive that feeling of, I think it's not okay, because I think it's just a normal reaction after some years of shock to sort of move somewhere else and deal with something else and sort of give in. And I think we have good reason not to give in.
Anna, thank you very much. Our next speaker is Jason, please.
Thank you. My name is Jason Biros. I'm the legal advisor here at the U.S. mission to the European Union. And speaking of Snowden Day, as we call it, I remember it very well myself. I was working as a lawyer in the State Department for the State Department's Intelligence Bureau. So it was a rather busy day and what became a rather busy 6 to 12 months of basically the only thing I was working on. It's a great opportunity to be here to speak. I was asked to speak particularly about the U.S.-EU dynamic since the Snowden events, and I don't want to bore people with excruciating detail of various reforms, but that event precipitated a rather significant, I think the term that you used, Tim, was sea change, but I may not be able to say sea change or not, but the processes that commenced on that day in the U.S. government were rather massive and extensive rethinks of the way in which the government had been approaching certain collection activities up until then. I try not to use the word surveillance because I think it's a little politically loaded and oftentimes not accurate. That's not a judgment on my part. I just think it's overused as a term. So I'll probably try to use collection a little bit more often. But and that's not a U.S. government position. It's really just for me. I find it to be sort of an abused term and used to kind of whip up sentiment that is not always well placed. So. As Tim mentioned, a series of reforms were undertaken over the course of many months and, in fact, years in Washington. And he's correct to say that one of the factors that drove those reforms was the not only public international reaction to what Mr. Snowden had to say, but also the reaction of foreign governments and particularly close allies and partners, although not exclusively close allies and partners. And the principal executive authority reform that was undertaken, as many people well know, is called Presidential Policy Directive 28. It has been much studied and much admired and much maligned, depending on one's perspective. But as someone who participated very extensively in the drafting and clearing and editing of that document, I can assure you that it was not a document that was undertaken lightly. I would say no fewer than 100 lawyers in the U.S. government were involved in trying to make that document work. And not, when I say work, I don't mean to enable the intelligence community to do otherwise what it was doing, but produce some document that looked pretty. That it was an extensive effort across 17 different agencies to come up with a system of reforms that would enable us to relate better to the concerns that were expressed as a result of the Snowden affair, but allow certain government entities to continue to collect the information that they needed, subject to the Constitution and the laws of the United States, in order to not only protect the United States and serve what the government's information needs were, but also to assist in the partnerships that we have with many allies and partners, including almost every country in Europe. So on the statutory side, we had the USA Freedom Act, which as Tim mentioned, was Congress's exertion of its authority to rein in one of the programs that Mr. Snowden had revealed about collection of metadata and restrain the access of that, the querying of that data to individualized targeted instances rather than on the bulk scale that it had been carried out before the reform. Which brings us sort of to 2015, which is when I moved from Washington to Brussels to start my position here. And I arrived here in the summer, which is typical, and spent 6 weeks not really knowing exactly what my role was going to be. And then the Schrems case came. And that was sort of the Snowden day #2 for in my career. And really since that judgment, there's been just an incredible amount of effort on both the Commission side and also the US government side to bring the commercial data relationship between transatlantically to a place where there is a meeting of the minds among the relevant government authorities and in a program that is robust enough to pass legal muster. I was fortunate enough or unfortunate enough to participate in all the Privacy Shield negotiation rounds. They were excruciating at times, only in that we had a lot of colorful personalities on either side who have very strong beliefs about how the negotiations should go. But I have to say that after an extensive amount of work on both sides, and including the Commission, the Privacy Shield framework that was developed was developed specifically with an eye toward satisfying the requirements of the Schrems judgment and moving the sort of commercial partnership of the two sides to a place where it would be more mutually revered, I guess. The Privacy Shield framework was finalized in February of 2016, I believe, and put into place in the summer. As most people know, we now have at least 2 court challenges, one direct and one indirect, against data flow transfers across the United States, across the Atlantic Ocean. The United States is participating in both of those litigations, mainly, if not exclusively, just to help the tribunals in question be able to have an accurate and extensive and detailed description of what US law and practice actually is. One of the difficulties that we had with the Schrems judgment was that, based mostly on the timing of the reference from the court in Ireland, the way in which the court in Ireland decided to refer the facts to Luxembourg and some other factors, it was disappointing in our view that the court in Luxembourg, at the time it issued its judgment, did not appear to have a full understanding, and in some cases had a misunderstanding of what U.S. law and practice permitted and was in terms of intelligence collection. And so our effort to participate in these litigations, of course, we strongly want the Privacy Shield and other transfer mechanisms to remain legally viable. But we also want that any judicial determination on the European side to be done with a full factual record, so that we don't have decisions coming without the information that we think the court should be able to have access to in order to make properly informed determinations. We have been working closely with the European Union on the process of doing that, and we'll be moving forward as those proceedings move forward. And over the next 12 to 24 months, I expect there'll be quite a lot of interesting developments in the cases, and we look forward to watching that. I would just close. I'll keep my contributions fairly general and leave it for questions. But when I speak at these events, particularly in Europe, I would just emphasize one thing, which is it has been, and understandably at times, rather sensational and desirable to perpetuate this division between the European approach to these issues and the American approach to these issues. And there's no doubt that there are differences in the way in which the two systems approach privacy. I wouldn't contend otherwise. But and one reason why I really welcome this panel, particularly the comparative views that are being expressed, is I would just caution everyone against aggrandizing the differences between the way in which the two systems operate, the way in which privacy is protected on both sides. Americans, especially government lawyers, find it rather baffling, some of the accusations that are made about the ways in which the American government does or does not respect privacy, and particularly in areas where some view the U.S. has stronger protections than Europe. This has been a recurring difficulty for us. In the immediate aftermath of Snowden, and by immediate I'll extend that to sort of the first 6 to 12 months. I think everyone understood that the political and shock value ramifications of that experience were going to dominate the political dialogue for some time. And it has, for the most part, I think, certainly in mainstream political discourse, calmed down in terms of the fervor. But I would just leave you with the idea that, in actual fact, we should focus on the 90 or 95% of things we agree on, and maybe those parts of the world that aren't doing any of that, rather than emphasizing too heavily the 5% on which we may differ. So I'll leave you with that.
Thank you very much, Jason. In the interest of disclosure, I'll tell you that the Privacy Shield requires the appointment of arbitrators. I'm one of the 16 arbitrators appointed by the U.S. government and the European Commission for Privacy Shield. And just to put this in context, based on 2012 data, the amount of trade between the United States and the European Union in 2012 was $2.7 billion per day. It's the biggest trading relationship on Earth, and no one's interested in seeing that decline. And so that's the reason when these things are, that there's a strong interest in having some sort of agreement that would allow that trade to continue. And you can well imagine how much of that trade includes personal data. Gus, do you have a question for Jason?
Imagine this hypothetical. If it was discovered that the Russians were spying on the American government and American people.
Hold on. Okay.
Would you and the American people be satisfied with a Putin presidential directive saying that they will treat Americans fairly?
Sorry, so what's the spying hypothetical? What kind of spying?
Collection, let's say.
Collection of what? No, I mean, quite honestly, I would need you to elaborate. Collection of what? Is this like a collection of U.S. telephone records or something like that?
Traffic data, all internet traffic data.
We need one example at a time. I'm not really in a position here to talk about, to malign a particular government's structure. I would say that to liken the U.S. government's approach to intelligence collection laws and practices to a regime that does not have anywhere near the rule of law structure, constitutional structure, separation of power structure that exists in the United States is exactly the type of comparison that I think does these types of debates a disservice. I don't find it a compelling question, respectfully. I think that it's very easy to demonstrate what the differences are between the U.S. rule of law system and the Putin regime. And I'm sure, I would hope that most people in the room would agree.
Our next speaker is Katitza Rodriguez.
Thank you, everyone. I have been asked to talk a little bit about what happened in the United Nations and how the outcome in the United Nations after the Snowden revelation have or have not have an impact in Latin America, which is the region where I'm working most of the time. So the right to privacy was like, after the Snowden revelation, the government of Germany and Brazil were to the United Nations trying to push for a UN resolution that recognized the right to privacy in the digital age. And that was a very big major outcome just right after the Snowden revelations, because until then there were even discussions whether within the member states that say that privacy was not a human right. Or not the human rights, the right to privacy. It was privacy rights, but not a right to privacy. That was a major victory, and that resolution asked the High Commissioner on Human Rights to write a report, more a substantive report about which are the standards, what are those standards to limit the right. And so the High Commissioner of Human Rights in that moment, Navi Pillai, came up with a report, a very substantive long report that make very good recommendations that states can implement at national level. Including the United States, but also Latin America, because in Latin America, at least, international human rights law and standards are really important because judges take into account those, they cite it in their court decisions, and it's part of the legal framework. So among of those kind of reports, one of the things that I like a lot, that they said that collection of data, it's surveillance, and that make a very strong condemnation that condemnation against the fact of having a huge high tech to find just one needle. It also says that metadata matters and it's sensitive data, even sometimes more sensitive than the content of communications, and also make an echo against the European Data Retention Directive, because it's not only that the United States export things to Latin America, but we also have the European Union through the European Data Retention Directive has exported that kind of law through the region with period of, for those who are not familiar, is the directives that have been declared invalid in the European Union that compel ISPs to retain data about who communicate with whom for how long, for certain period of time, a mass surveillance law. And so these have been implemented in many countries in Latin America. So the fact that this document echo that data retention, the collection of all metadata that should be neither necessary nor proportionate was like a good outcome. After that, the General Assembly keep publishing more resolutions of the right to privacy in the digital age, and then we see that the mechanisms within the United Nations start assessing more in the Human Rights Commission, assessing the state's compliance with international human rights standards, including the right to privacy. We see NGOs like Privacy International with their network making submissions to the United Nations to assess compliance and call attention to the things that at national level was violating the right to privacy. We also see that those standards were using as education materials. For instance, EFF is working with the judicial schools from all Latin America, training judges through the region on international standards on the right to privacy. So what happened with all those documents? There were very good documents, but if nobody put it in place, it could just be like in the cloud. But we don't want that. So what we did, we see in practice a couple of victories, I will say, when I saw a real impact from these documents from the UN in the domestic level. So in Paraguay, they were discussing a new bill that was going to implement the data retention, like similar to the data retention directive. The local NGOs were bringing all those papers and distributed to all policymakers. I have the opportunity to testify in Congress, and we also mentioned the decision in the European Union that it was declared invalid, and we were able to stop the bills thanks to those documents that were developed at the United Nations, I will say, because it gives us more talking points that it's not just EFF or a local NGO saying this, but it's actually the UN, or it's the High Commissioner of Human Rights, and it's other people. And so then we see a similar bill have been a decree being rejected, also in data retention in Chile, but we also saw some lost, although it's not totally a loss. It's also we see in Mexico that the Supreme Court in Mexico actually said that the retention of all the data was constitutional, but even though they put safeguards that the telecom law, the law that was implementing this data retention provision, didn't have like metadata matters and it's matter as equal as content. So to access metadata, you need judicial order. And that was a success. But it's not all good, obviously, and even less in surveillance. And even though, and even less in countries which are democratic, but their institutional infrastructure is still weak. Like there is a lot of corruption in the judicial power, there is a lot of secrecy, and talking about all these things is even dangerous. It's not something like, when I moved to the US, at least I can speak about these topics, and I was saying to my bosses, and you don't go to jail, and nobody is going to kill you? No. I'm like, okay. That kind of talk doesn't happen in countries when, it's not happening more, obviously, but it's still risky. And they are doing it, but it has a risk. So now we saw that it's not also about mass surveillance. We see a lot of targeted attacks. And the surveillance technology, the technology is the same. It's used by the US, it's used by the Europe, but it's also being bought by the developing countries. And one of these is the several attacks that we saw against journalists, activists, the use of malware to attack independent media. So just the case in Mexico, yesterday, one of our colleagues from the Red en Defensa de Derechos Digitales was telling us that there were 79 cases that they document where there were victims of malware attacks. And when they were doing the analysis of who were these persons, they were activists, human rights defenders, independent journalists, and those attacks were happening in moments where these people were criticizing the government. Just for instance, when a traditional human rights NGO was fighting the law against torture, or when they were fighting the report against the killing students of Ayotzinapa. And some of the things. And we have a lot of cases published by Citizen Lag, also in the South Cone of South America, where also they're having a lot of malware attacks, clone of political opposition parties with that threaten freedoms and attacking these investigative journalists, also judges or activists, political opposition parties. But I just want to close that because I'm on time. I want to say that there are many things to do from education to bring all these documents that we get in the UN, and that they are not laws. It's soft law. It takes time, but you can put them into force. They have incited in many court decisions, and they are being used now, but we need more litigation, and that's a concern in the region. Thank you.
Thank you so much, Katitza.
Katitza, I'm curious. The flow of policy knowledge is one thing, but it's also the flow of the technology and capabilities. And a lot of this, say for instance in Colombia, was motivated by the war on drugs back in the 1980s and so on and so forth. With the rise of China, the rise of Russia, and of course the continuing US influence in Latin America, how do you think it's possible to stem the tide of governmental enabling of surveillance, foreign government enabling?
Well, I wrote a little bit about this before, about how the US was fooling, this was many years ago, before Snowden, some of this technology in the context of the war on drugs. We know, thanks to the hacking team leaks, that for instance, most of the traffic, it was a leak that was saying most of the traffic was passing through the embassy of the United States. And we don't know more details because it was just a single leak, and we haven't had any Snowden in those countries. So it's a lot of secrecy. But I think that it's very certain that there is one case, it was the Wikileaks diplomatic cables, I just remember, where, and this was interesting because it was a conversation between the government of Paraguay with some of the embassies in the United States, and they were saying, we, and the United States was saying, we are having our drug operation happening in the US, but this government is asking me to actually use it for political purposes, but that will be in violation of the rule of law. That's what the diplomatic person was saying in the United States. But in another cable, so in that way, the United States was seeing like concern about the political pressure that they were having. But at the same time, they were ascertained that their operations could be in risk. So they were in this kind of debate. In the other ones was more strong that actually there, I think it was with Panama, where this drug operation was or going to be really, really in danger if they don't help the local government with their political agenda. But they were very concerned we should recognize that in these leaks, in these mails, in these conversations that they were having between themselves, they were really concerned about this kind of political influence and the needs for the local governments to use it for different purposes than for drug trafficking.
Thank you very much to all of our panelists. Now it's your turn. So time for some discussion, and we do have time for that, thanks to their courtesy in staying within their time fairly well. So let's see, questions. I see this gentleman here first, then you, then you. Please, is there a microphone for the questions? I think not. So you're going to have to use your coxswain voice. Speak loudly.
Mario Hammer from the Fundamental Rights Agency, the EU Fundamental Rights Agency. I'd like to ask the panel, and in particular maybe Anna and Tim, you mentioned it, but also I'd like to have the perspective of the US on this. Tim mentioned very briefly the legislation that followed the Snowden revelation in other jurisdictions than the US. And when we did our report that covered the EU 28 intelligence law, one element that we really underlined was the enhancement through reform. Enhancement of details that Tim was mentioning. And I'd like to understand whether, according to you, there would be a direct link that I believe we can make, but I'd like to have your opinion, between precisely all the discussions that have been taken place after the Snowden revelation, the reform, including, for example, the discussion in the UK around the IP Act, basically enhancing really hugely transparency, and the link to it, the question of trust that needs to take place. So basically, transparency, trust, and in this area, which was really not very developed before Snowden. And I'd like really to underline this because I believe this is what one of the elements that were triggered by Snowden.
Good. Thank you very much. So we have a very big question, which could be a panel in itself. So I'm going to ask the speakers to address it, but concisely if possible. And we'll start with Tim.
Sure. Yeah, I think that the transparency reforms were probably the most important, and I would encourage. That's where I think the U.S. has actually led quite a bit. If you look at the kinds of documents that were made available through the Office of the Director of National Intelligence's website, IC on the Record, these are very detailed, highly classified documents made available. Now, to be fair, this was tactical, certainly at the beginning. This was, we've revealed a bunch of mass surveillance programs. Now we want to tell you all about our privacy and how they work and how we safeguard them. But the result of that was to make on the record much more details available about how surveillance works, and that has had lasting implications. And I think this is one of the tough nuts to crack for intelligence agencies. I had a panel discussion at Brown shortly after in the fall of 2013, and I just was struck by one statement from an intelligence official. He said, transparency is not part of the intelligence community's culture. we are designed to keep our own secrets and to steal our adversaries' secrets, not to be transparent. And so this was a major culture shift. And I'd say that it has many, many possible benefits, but it shows that we can have a level of transparency about these activities that I don't think anyone who worked in the intelligence community ever thought was possible. Yeah.
Great. I want to just underscore one thing that Tim said. He mentioned this IC on the record, intelligence communities on the record, and I wanted to mention that in terms of something you can access. The URL is dni.gov/OCLP. So it's Director of National Intelligence, dni.gov/OCLP, Office of Civil Liberties and Privacy. I'm on the email list. You can get on it, and it's a great way to keep track of some of the things U.S. government is releasing. Anna.
Just to get it right, so the question is, to me, is whether and how there is more transparency in German law after Snowden?
Well, and also through the work of the inquiry.
Through the work of the inquiry.
I wanted to understand your opinion on the amazing publication, the 1,200 pages or 2,000 pages that we were talking about, which do provide a lot of information about what happened.
Okay, well, I agree that I think it's a great accomplishment that we have the report and that we have the inquiry, but in general for German government or also intelligence, I don't see any development towards more transparency. We didn't have specific laws asking or providing for more transparency. In the aftermath of Snowden, the new laws, in my opinion, don't provide that. And as for intelligence, this was explained before, they are not friends of transparent anything. so there was nothing to be expected from there. In fact, the one head of the BND that was actually kicked out of his job as a result of the inquiry, he had a sort of a bit of a different air to him, in at least proclaiming that he would like to modernize intelligence a little bit and be a bit more let's say, informing the public about what they are doing in the most general sense. And I see more of a development in the other direction currently.
Thank you very much. Would anyone else on the panel like to comment? Jason, Gus? Okay, good. Oh, Jason, go ahead.
I don't have much to add to Timothy's response. It is true that this has been something on the U.S. government and intelligence community specifically has placed a tremendous amount of emphasis and importance on in the last few years. They take it very seriously. There are entire offices that are pushing various agencies to be as transparent as they can. It is one place where the U.S. government, I think, as Tim mentioned, does feel a little bit out in front of others. And in response to the idea that it was tactical, I mean, of course, there are many considerations that go to these decisions, but part of it was to ensure that, after the Snowden affair, that not all the information on those programs was revealed, and there was other information that the U.S. government wanted to put out there to make sure that it was a more complete picture for those people who were responding. So another point I would just say is just, irrespective of how one feels about the result of the legislation on 702, I mean, one aspect of having sunset clauses on authorities like this is that it brings it back to the legislature, and the legislature then has to have another public debate on what these powers should be and how they should be restrained, and in this particular case resulted in some enhancements in transparency requirements, et cetera. So these are not snapshot questions, right? This is an evolving process where we have to make adaptations based on the place in which various democratic societies find themselves.
Thank you very much. You're the next question, please.
Yes, thank you. My name's Annie Mashon. I used to work as an intelligence professional with Amplify, and I now currently work with a number of, should we say, intelligence dissidents around the world, including Snowden, including Hurley, Moderator, people like that. So my question follows on from Mario's to a certain extent. Listening to the speakers, I applaud the efforts to try and learn from the mistakes made prior to every Snowden's disclosures. But it strikes me that the laws that are put in place to reform, at least in the UK, the US and Germany, are actually just legalising what has already been illegal activity carried out by spy agencies for many years. And bearing in mind that Snowden made his disclosures 5 years ago, and the technology will have evolved in those 5 years exponentially, what on earth are they doing now that we do not know about, which might still be illegal under the terms of these new reform laws? And how do we find out about that? What suggestions do people have for increasing the accountability of our spies, who we know who can lie to us very easily? So that would be my question.
Tim, you start.
I guess I'd like to take on directly a little bit this idea of we legalized all the illegal activities, because that kind of begs the question of whether the activities were illegal or not. And I think that there are honest differences of opinion among lawyers, and the problem is that the system is set up when there isn't transparency to basically say, if I'm a lawyer working for an intelligence agency, the intelligence agency asks me, is this legal? If I can make a credible legal argument in a memo that it's legal, that's the end of the matter, because there isn't checks and balances that go in and say, is your legal opinion correct or not? And so when those activities are publicly disclosed, obviously a number of lawyers will argue, hey, these are illegal. Others might argue, that they're legal and it might be more or less persuasive. What I think we need to avoid the problem, the trap that you're setting, is first, we've talked a lot about transparency. The second thing I want to talk about is checks and balances. And this is difficult, just looking at the American context, but I think it's analogous in other countries as well. In Germany, you have this concept of the government versus the parliament. In the United States, we have the concept of executive, judicial, and legislative branches of government. And typically, intelligence has been seen as an executive power that's shrouded in secrecy, and that's a result of the president's power under Article 2 of the US Constitution as commander-in-chief. And so you have one branch basically advising itself on what the law means without a check and balance in secret. That is likely to result in a skewed view of the law. And I could argue that what we want is we want a much more transparent process in which we bring in other branches. This was my greatest disappointment about the 702 debate. I thought the 702 debate should be about a lot more than 702. I thought it should be about, frankly, 702, despite all of its flaws and problems, actually takes a mass surveillance activity of the US government, a kind of activity that had never been subjected to judicial review or regulated by the Congress before 702 was passed, and it tries to fit it into this checks and balances. Imperfectly, all the problems that we have seen, but the other activity, EO 12333, the executive order that allows the NSA and other agencies to collect intelligence outside the United States, has none of those checks and balances. So my biggest, proposal for reform, which never got anywhere off the ground except in, a Hoover Institution, thought paper, was that why don't we take some of those ideas and put, why don't we have the courts of the United States reviewing all of this intelligence surveillance instead of just the intelligence surveillance under this one law. But the basic point is to take the systems of checks and balances and the transparency and subject these questions about whether certain activities should happen and are legal to more than just the decision of the executive branch policing itself. And then, and just to be clear about this, that doesn't mean that, Privacy International's view of what the law is always going to prevail. It just means that it's subjected to a much fairer system and process. And that is, frankly, in the long run, going to benefit the intelligence agencies because they will have a stronger legal framework for the activities that they do conduct.
Others?
Maybe just briefly, as for whether illegal or not, of course, I cannot really judge what's going on in the United States, even though my impression was that some of it was deemed to be illegal. In Germany, we have proof that there was illegal activity going on that I think is accepted by pretty much everybody, with a few exceptions. And yeah, I think what's needed, coming back to the question, is more information, and that relates also to the question about transparency. It's really sad that only Germany had an inquiry like that. It would be so interesting to see how these things play out in other countries, and if you have the chance, support parliamentarians asking questions. Of course, everyone has different laws as how this can be done, but I think just already to continue to ask questions about the details of these things can be very helpful in the future, and it would be, even though it's so much later, it would be really useful to have more information also about the cooperation between the other countries and how they are exchanging information about these types of things. And then the other thing, of course, just very briefly, is we need more whistleblowers, because the governments and the intelligence will not hand over information voluntarily, and more protection for whistleblowers.
I would just, with respect to Tim, I don't think his characterization of the role of independent courts in the U.S. on almost said it myself, surveillance on intelligence collection was actually quite extensive enough. I think it's much more robust than that, beyond just a single law. And I would point out that the federal courts were called upon to rule on the legality of a particular statute and how it was being interpreted by the government, and the government lost that case. And that's part of what checks and balances are meant to do.
I'll take your question in a moment. I just want to recall to you, though, in response to your point, Anna Roth's very good example that she gave. There's a difference between the dry letter of the law, is something legal or not, and does it make, does it follow a common sense practice? She noted that there was a communications law they were following. Meanwhile, the technology had changed, so they were collecting information through digital means. So they were, when you said that, I thought, well, they were complying with the law, right? They weren't violating the law, but meanwhile they're collecting reams and reams of information that people would object to. So again, this kind of, okay.
They were actually not complying, and they noted that in internal communication, basically saying, well, it's impossible to comply with the law because it doesn't make sense, so we're just going to do it differently. This was noted inside intelligence, just nobody else knew.
So indeed, with these technological advances. So again, I'm just underscoring the idea of sunsets, transparency, and checks and balances. Yours is the next question.
Yeah, my name is Roth. My question is to Jason, and tying into his last remark about the federal courts. How am I supposed to take you serious about the difference of only 5% when there's the Kenyan embassy jurisprudence which says you as a non-US citizen outside the United States are subhuman without any Fourth Amendment rights? I mean, even the Russian Federation in paper had more rights there than in the United States because it's a signatory to the European Convention on Human Rights and the Convention 108. So in terms of at least on paper, my rights are better preserved in the Russian Federation and the United States.
Can I just, I mean, I know.
Well, I asked that Jason.
Yeah, go ahead.
My answer is you don't have to agree with me, certainly. Fourth Amendment jurisprudence has been developed over the course of 250 years. It is this constitutional system of privacy protections that we've had in place since our beginning. And you're right that the rights of non-U.S. citizens outside the United States under the Fourth Amendment are considerably less than they would be if they were present in the United States. I can't disagree with that. I would caution you against assuming that comparable systems are treating non-citizens abroad exactly the same as they may be in their own territories. But I mean, beyond that, you may be right that on paper, I'm not a Russian lawyer, maybe on paper that your protections in here from the Russians would be greater. I'm not sure how much comfort you should take in that, but that's for you to decide. I don't have much more of an answer than that, I'm sorry.
I guess I would just say that, the Soviet Constitution famously had an enormously beautiful list of rights that were protected in law, and I would go for a policy directive that's actually implemented and actually followed by people in an agency over a beautiful and more powerful set of rights that have no practical impact because nobody obeys them any day of the week. And I think that I guess this is just sort of my fundamental reaction. When you're talking about all of this kind of intelligence activity, I think there's a tendency to think that we need to have, that the same practices have to be the same across every state regardless of their fundamental democratic character. And I fundamentally reject that. I just don't think that's true. I don't think that Russia and China, regardless of what they say in their law or in their policy, are going to be acting with the same care towards the fundamental human rights of anyone, certainly not Europeans, than a country like the United States. And I think that as a result, I think that we want to have a dialogue with our democratic allies about what rules we want for surveillance without necessarily involving states who will be, can be counted on promising whatever they want to promise because there's no cost. I can easily go to international forum and promise to obey every rule in the world if I'm never intending to obey them. If I actually think I'm going to make some effort to obey them, then it may be harder for me to make those kinds of promises.
There's just maybe one thing I want to add to that debate, and I think it's an important debate to have, and there is really much to be said about that, but I think it's also important to actually keep in mind that while we can discuss about the legalities about differentiating between citizens for a long time, it's important to understand that technically that's not possible, right? Like in the digital age, you cannot know who actually wrote a certain email, and you have options for filtering, and you can get, like, to a certain extent, you can guess what the nationality is, but in fact, actually, technically, it's not possible, and that's another reason why I think it's important to stop making these differences.
Well, ladies and gentlemen, in this short interval between luncheon and the coffee break, we've only been able to really just glance the surface of this interesting and very important topic. thank you very much for your kind attention, and please join me in thanking sincerely the speakers on this panel.